Now call case number 115259, State of Kansas v. Dwayne Hambright.
May it please the court, Clayton J. Perkins appears on behalf of Dwayne Hambright. I would request 3 minutes for rebuttal.
3 minutes is granted.
To give a brief procedural summary for this case, Mr. Hambright pled guilty to a severity level 7 felony criminal damage to property count. As part of that plea agreement, he agreed to pay in restitution $60,000. The case had a presumptive probation sentence and a duration of 24 months. But at sentencing, the judge said, based on Mr. Hambright's welfare, that they would impose a longer term of probation of 36 months to give him more time to pay back restitution. Mr. Hambright appealed to the Court of Appeals under an argument that was an illegal sentence because it was not a departure finding, but was a finding under the wrong statute. And the Court of Appeals found that it is a discretionary sentencing matter, and that is how the case comes before this court. It is a question of statutory interpretation, which is reviewed de novo. And the long and short of Mr. Hambright's argument is that this court was correct in State v. Whitesell back in 2000 in interpreting the provisions now contained in KSA 216608, and has been relied on by the Court of Appeals in several published and unpublished opinions. And that the decision by the Court of Appeals in this case, essentially saying that Whitesell is no longer good law, was incorrect. And that ultimately, Mr. Hambright received an illegal sentence because the duration set by the statute is 24 months of probation. He was sentenced to 36 months of probation, and that wasn't supported by a departure, which is what is necessary.
How's that done? How does a district court impose a durational departure on a probation term, given that we have a statutory procedure that requires a jury to decide durational departures?
Well, and there has never been a jury trial requirement, like an Apprendi requirement, found for this type of sentencing. So even in post-Apprendi cases like
don't we have a statute that says how durational departures? So whether Apprendi applies or not, statutorily, we have a procedure for durational departure.
For upward durational departures, yes, we do. And there's never been an opinion that says that is the upward durational departure statutory proceeding is what is necessary for these types of durational departures in probation sentencing. Even cases after those provisions have come into place have been relying on the sort of other departure procedures for, say, the same as dispositional departures or downward durational departures, where the sentencing judge can make the findings necessary, because that's only been applied in situations where it's been found that the Apprendi rights apply.
Counsel, Whitesell was decided before our current rubric for statutory interpretation and construction, correct?
That is correct.
Okay. So how do we get mandatory out of the statutory language? Let's assume the absence of Whitesell for a moment.
Mm-hmm.
How do you get 24 months as mandatory out of the statutory language? when it says recommended?
Well, and I don't think you have to get 24 months mandatory out of
Okay.
it. In the cases where mandatory is explicitly used, mandatory is mandatory for that
Sure.
sentencing, and if there's a special rule for a departure from a mandatory sentence, it's very clearly laid out. Like the Court of Appeals cites the post-release provisions, where there's only one way to depart from the mandatory term.
Maybe I'm confused. I thought your argument depended upon the 36 months being overlong, being in excess of what was required by the statute. Does it not?
Well, and there are tiers, I think, between mandatory, then the presumptive or recommended sentences, which are subject to departures.
Okay.
And then
You're just saying it's presumptive, not mandatory.
Yes.
Got it.
Yes.
Thanks.
Can you help me here? I understood that the durational departure to 36 months was basically related to the restitution, and to make it a more his ability to pay restitution was part of the main reason that probation was extended. But then restitution has been remanded back to the district court for a workable plan. So aren't those two necessarily tied together in this case? And I guess why is if 36 months, and it may be a question more appropriate for Ms. Isherwood, but why aren't those two intertwined in this case? If one's sent back, it seems like they both should be going back. Because it doesn't appear to me now that the district court has the ability on the remand to change the duration once it's been set, and this was all dependent on the restitution plan.
Yes,
Wasn't it?
those two are entwined, and that's sort of the strange thing about this case, in that there are several ways in probation for the probation term to sort of fit with the restitution plan. Particularly, probation can be extended if restitution hasn't been paid back, and so it's really
But here the duration was made because of the restitution plan wouldn't be workable unless it was extended, but the workability aspect is being sent back to make it somehow more workable. I'm not sure what will now be taken into account, but it seems to me these two are dependent on each other. I don't know where that puts us, but it's in an odd posture, it seems to me.
And I do agree it is in an odd posture, and that the plan can be workable, and then if there are extensions that are necessary under the statute, that could have happened. It's really, there was no reason for.
What really happened here is we had an abuse of discretion because the district court applied the wrong legal standard. It applied the standard in C5, and we all agree, everyone in the courtroom agrees that that was the wrong standard to apply, correct?
Correct.
But you haven't asked us to reverse for abuse of discretion. You've asked us to find that it's an illegal sentence, haven't you?
Well, yes, based on this court's precedent.
But this is a direct appeal, right?
Yes. Yes, so of course at the time that I was filing this brief, I assumed that Whitesell was correct, and the Court of Appeals cases applying Whitesell was correct, and so the argument was basically there was no reason to think that this was.
But even without Whitesell, the court applied C5. C5 doesn't apply here.
Yes.
And so the court applied the wrong legal standard. That's one of the definitions of an abuse of discretion, isn't it?
Yes, that is.
But can we get there? How can we get there when you didn't ask us to reverse as an abuse of discretion?
Well, I did not brief it that way, but at the same time, at the time I was briefing it, it was in reliance of the existing case law. So if this change, I mean, it is still, I guess, a sentence that is out of conformity with the statute because of the statutory language there. I guess I'm not quite sure.
It's not out of conformity with the statute, it's out of conformity with Whitesell.
Yes, and well, Whitesell's interpretation of the statute, yes.
Right. Well, we don't know that the Whitesell was interpreting this statute because the Kansas Sentencing Guidelines Act defines durational departure as a sentence that's inconsistent with a presumptive term of imprisonment or non-imprisonment. They could have been applying that guidelines provision here rather than interpreting what it meant in the statute that sets the terms. We don't know because they didn't really say. Mm-hmm. They just jumped right in and said this is departure.
Okay. Yes, I suppose I think I understand that.
And I guess my problem is why isn't this much to do about nothing? Because under C7, your client can be on probation until she pays restitution. You didn't need to set a 36-month term. Could have set 24 and simply imposed. C7 says if there's an order of restitution, the period may be continued as long as the amount of restitution ordered has not been paid. So it seems counterintuitive to me to say that the reason we have 36 months is because there's restitution to pay when there's a specific statute that says you can just continue it as long as it's unpaid.
In a way, again, this is a little bit ado about nothing because that statutory provision does exist. So why was there the need to extend it to 36 months over 24 months? And why was there need to sort of try to craft a restitution plan that would fit within sort of 36 months, which...
well, it was 72 months. It was 36 months with one extension of another 36, wasn't it? Isn't that what the court said? It doesn't matter. Yeah. The 36 months wasn't enough to pay $60,000 at whatever it was, $500 a month or whatever, right?
Yeah, yes, and the district court said it didn't seem like it would be possible to pay it back in that time period either. Yes, and so a lot of why this case is now before this court is purely what statutory procedure applies, what procedural protections apply. And again, I think it is consistent with 6608 and with the KSGA that departure findings would be made in these situations. And the additions to 6608 in the C3 through C5 support that reasoning in that they clearly point out that the legislature can create and describe a discretionary range for sentencing, which is not what occurred with the set durations for severity levels up to from 1 to 7.
Assume that our plain reading of 6608 doesn't get you where you want to go. You have to have Whitesell. Then we're into stare decisis.
Yes.
Explain to me why there wouldn't be more good than harm if we overturned Whitesell.
Well, there's a couple of reasons. And with stare decisis, one of the things that I was looking at that is the realization, or is the statement that the doctrine of stare decisis is particularly compelling in cases where the legislature is free to alter a statute in response to court precedent with which it disagrees, but declines to do so. And that we are now 18 years after State v. Whitesell, where this has been the procedure, and it's been the procedure in all probation.
I understand legislative acquiescence, but that wasn't what I was asking. One of the considerations on stare decisis is whether if it was erroneous, whether more good than harm would come about from changing the law. And I'm asking you why there would be more harm than good.
Well, the first is it would remove some of the procedural protections that exist in the probation sentencing process, and judges, suddenly would be able to sentence, as the Court of Appeals says here, anywhere in the range up to 60 months, without, which has sort of a couple of concerns. The first is a lack of notice that defendants are going to be going into probation sentencing with no notice provided, as the departure statutes require that they could get up to 60 months probation. And so defendants going into, like Mr. Hambright, who are thinking they're going to get 24 months, may not be.
Wouldn't any lawyer just tell their client you could get anywhere up to 60 months?
And that's what a good lawyer would do. The sort of
You're
other
just saying
side.
No official notice from the court or the prosecution.
Yes, although that would still be impacting the sort of stability of the plea process and of these sentencing statutes as they've worked. And the other side effect would be, I guess, for the last 18 years, lawyers haven't been telling their clients that, although that would apparently be the case. And the other side of it is that there's sort of inconsistent language in the Court of Appeals opinion, but there's no, if this is just a discretionary determination, there's also no lower bar put in there, that it would seem to me. So it might be that you go into probation sentencing for a severity level 7 felony, and I guess the judge would seem to have discretion to impose 1 month of probation as a possibility, and attorneys were also not aware of that in their request to the district court for discretionary sentencing.
Counsel, I see you're out of time. Do you need 30 seconds to wrap up, or do you want to wait till rebuttal?
I will wait for rebuttal. Thank you.
Do we have any more questions? Thank you, counsel.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state. Just to answer a couple of the questions that are on the table, Justice Rosen, you asked, where does this put us? These are inextricably intertwined.
Aren't they? I mean,
they are
seems to me.
To some degree, but also the court also imposed the extension as a result of his pervasive criminal history. So there is still that factor, and the restitution will still be in place when he goes back. It's not as though he will be absolved of restitution, so that factor. And it
Maybe. I mean, you don't know. I mean, it might not be workable, this particular defendant pay rest. I mean, you
Sure.
just don't know what the plan's going to be.
But there is at least another factor on the table. Justice Johnson.
Counsel, just a moment before you continue. On the criminal history, it got mentioned, but then it got turned back around to restitution again, didn't it? That the public had an interest in, because of his extensive criminal history, the public had an interest in him paying restitution.
He did, but he also mentioned that the fact that the defendant, in looking at his PSI, he went through some detail about the PSI indicated that he was committing 1 new crime a year. So there was a mention of the criminal history in and of itself, separate and apart from how that factored into.
What would have happened had the defendant at the 2-year mark, the 24-month mark, come into some money and paid the remainder of the $60,000? Then he's stuck for an extra year on probation, right?
I wouldn't say he's stuck. I mean, it's a court order that it's been extended in part because of his criminal history.
Okay, so you fall back on criminal history.
Well, I mean, that's what the record speaks to. That's one of the factors that was relied upon by the district court when it imposed the extension.
You don't accept the idea that the 36 months was a direct result of the district court's effort to give him time to pay?
I think that is part of it, based on what the district court articulated. I think that is part.
And if that's, why isn't that an abuse of discretion, I guess would be my question. In other words, there is a statutory provision that permits the extension of a probation if it's not been repaid. But to do that on the front end is an assumption. It relies on an assumption that I'm not sure is justified. It's an assumption that this defendant won't pay.
I think it's taking into account the defendant's factual circumstances.
But factual circumstances can change.
They can
I mean,
change, but
we've had cases where the state has made that argument as to a workable plan.
sure, but the court could have, I mean, how would it ever arise at a conclusion or arrive at a conclusion at the time of sentencing if it takes all potential hypothetical scenarios into account? The court is sentencing based on the facts as they are at that time.
But the statutory scheme seems to me to anticipate that if I've set aside criminal history. I agree that's a separate question. But if the driving force here is restitution, the statutory scheme seems to me to contemplate a revisiting of the length of probation at the conclusion of the ordinary term based on whether or not it's all been repaid.
It does allow for that under Section 7, if I'm understanding.
Right.
If your question is whether it's still outstanding.
But if you prophylactically at the outset impose a longer term, I'm concerned that you have undercut the defendant's ability to fully pay off restitution, and within a shorter amount of time. And now we have an extended period of probation, which frankly serves no purpose. That's assuming, of course, that the original purpose was to allow for restitution.
Sure.
That's my concern. So if you could just address that.
And I guess I would repeat that it's the factual circumstances present before the court, that its intention is still within the realm of grace, that he's trying to take into account the defendant's circumstances by making it longer and making his payments more
manageable. Well, that would be true if he said, and if the amount is fully paid off in month 25, probation will end.
And I suppose the district court could revisit that upon motion of the attorney. But at this point, whether it's an abuse of discretion to exercise his grace and say, I'm going to extend this to make, in the court's mind, your payments more manageable, I don't think that's an abuse of discretion. I think he's
I agree. The intent could be, as you put it, grace-oriented. I'm concerned about possibly unintended consequences.
And I think on motion of his attorney, they could revisit that issue at the conclusion of probation.
And I'm concerned about you getting into the judge's mind for us. That's contrary to the judge's statements and contrary to the journal entry. That specifically, the statements talked about the safety of the public and welfare of the inmate, which are the specific items under C5, and the journal entry specifically refers to C5, and don't we all agree that C5 was not applicable here?
Agreed.
Okay.
But
and so why isn't that the application of the wrong legal standard?
Well, first of all, I want to back up to the welfare part, because I think in saying the welfare of the defendant, my interpretation of that statement was his ability to pay. Because otherwise, I don't understand how else the welfare of the defendant would be affected by extending his payments for the restitution issue. With respect to C5, I think if you look at that, the statute as a whole gives the court discretion. And the district court can be right for the wrong reason. And here, there is no precise mechanism that limits the court's ability to extend that probation up to that 60 months. So I
think you're misunderstanding me. Even if we were to say that under C1, that those are advisory only recommendations, that you, in accord with the panel, it could be 24 months to 60 months. Even if we determine that that would be a plain reading, if the court applied the standard under C5 that doesn't apply, we've been fairly clear about the application of the wrong legal standard is an abuse of discretion, and send it back and say, apply the right standard. And so the district court could end up in the same place, but we don't do that for the court. We don't say, well, the court would have exercised the discretion under C1, so we'll let it go, or could have. We require the judge to exercise the discretion, don't we?
We do. And the court did exercise its discretion here. Again, there is no precise mechanism for severity level 7 felonies. They can just be extended 60 months. And the fact that the court necessarily tied it to C5 doesn't mean that its findings would be any different under its general discretion that is allowed in extending it to 60 months.
Could the district court have just said 36 months probation?
Yes.
No reason given. That's your position.
That is, under the plain language of the
Right.
statute, there are no particularized findings required. And under the Court of Appeals opinion, we would say that it's reasonable because under the plain language of the statute, there is nothing that mandates substantial and compelling reasons, and there's nothing that indicates that would be a departure.
So
yeah.
go ahead.
So you're saying it wasn't an abuse of discretion because he had the discretion to apply any standard he wanted to, including the C5 standard, if that's what he wanted to do.
If he wanted to use the language of C5 in this circumstance, even though these weren't C5 felonies, I think that is acceptable and a proper exercise of its discretion. I do want to back up just a minute. Justice Johnson, you had said, where does this put us with Witzel and stare decisis? And I think what needs to be done here is clarification, because as you pointed out, it's not clear from Witzel whether they were relying on this statute or whether they were relying on just a departure statute. And if we could get some clarification under this statute and point out that it doesn't require substantial and compelling reasons and doesn't require departure, I think that allows for the uniformity in sentencing that we strive for.
And what do we do with the guidelines provisions that defined a durational departure in terms of non-imprisonment terms?
Well, obviously this court can't rewrite that statute. That's not within the latitude of this court, but as far as this specific provision, I think we can lend clarity there in affirming the Court of Appeals opinion.
And how do we do that? That if it is a durational departure, like Weitzel said?
It's not a durational departure. The statute doesn't
But
allow
the
for a durational
guidelines
departure.
refer to a durational departure in the language of, quote, term of non-imprisonment, end quote. And so if the guidelines say that if you don't use the presumptive term of non-imprisonment, it's a departure, then how do we get around that? If we just say it's unfettered discretion, then that's superfluous language in the guidelines, and we say we don't interpret statutes to be superfluous or meaningless, don't we?
We do. We also say that we're not going to read language into a statute that's not readily contained therein. And so to depart from what the Court of Appeals is saying here would be to read 216608 to say not only is that extension a departure, which that language isn't here, but the court also has to make substantial and compelling reasons. That language also isn't here, nor is 216608 cross-referenced in the departure provisions.
In your reading of back to 6608,
Yes.
what does C1B, which is I think what we're talking about here, mean?
Yes.
Recommended duration 24 months.
It would be the state's position that that is the bottom, that would be the starting point. And then the court has the discretion to go up to 60 months from
But
there.
that's not what it says.
You asked what my interpretation of it is, and
Well,
that
but
would
you're
be my
making a plain
interpretation.
language argument. I mean, saying we can't add words and so on. It doesn't say anything about that being the bottom.
It would be my assumption that if that's the number that's designated, that would be the starting point. And then they have a top number designated. To me, if you have a top number designated, the other would necessarily be the bottom.
So the recommended duration doesn't carry any legal weight. It's just sort of an aspirational statement by the legislature.
It's a starting point by the legislature.
Well, then how does that provide, you 3 or 4 minutes ago, or maybe you mentioned about the importance and the part of the purpose of sentencing guidelines is to provide continuity and consistency. That just puts that on its head, doesn't it? There's just
No,
how does it do that? Basically, what you're telling district courts, given your interpretation, is that there's a recommended period, but you don't have to. You do whatever you want, and without supplying really any justification for it.
Okay, first, I'm not saying they don't have to provide justification. There is an abuse of discretion standard, so there are checks and balances. As far as between 24 and 60, to me, it's no different than a presumptive range that gives the three, the middle, the bottom, and the top. And the court can, as it deems fit under the facts and circumstances of the case, impose one of those terms. That's what I'm recommending should be happening here. When I talk about consistency, I'm talking about the application of the statute, and that we don't need district courts thinking that they need substantial and compelling reasons, and other courts thinking that there is not a departure required. So I'm saying clarify what the process is. That's my argument.
And again,
for
articulate for
consistency.
me why 6 months, when the recommendation is 24 months, isn't an appropriate place to impose a probation. Why wouldn't a 6-month duration be okay?
Based on the magnitude of the felony, the legislature has determined that 24 months is what's appropriate. Now, with the lower level felonies, they have given some more specification on the court's checks and balances, saying that particularized findings need to be made there, and they've treated those a little bit differently. Here, the belief is that the 24 months is the appropriate starting point based on the group of crimes under consideration.
So what does a court have to do to get off the mark?
It would have to be a proper exercise of its discretion.
Which is not substantial. You're saying not substantial and compelling. So what is it?
It would have to be legitimate factors, like in this case, restitution, criminal history. They have not provided a list of those factors because substantial and compelling reasons aren't required. It's an abuse of discretion standard.
And that same standard would apply to a 6-month probation sentence.
Not under the plain language of the statute. The starting point.
I don't understand how you can have it both ways. I mean, how you can have it both ways. The state gets to require, it's a departure if you go down, but it's not a departure if you go up. I'm having trouble with it.
I didn't say you could go down. I think the starting point is 24 months and you go up to 60. That's the plain language of the statute. Do you have another question?
I've got several questions, but
Fantastic.
Are you ready?
I suppose. Yes and no.
Yes and no. Weitzel.
Yes.
Weitzel clearly applied the departure procedure, treated the 60-month probation as a departure sentence.
Yes.
And that was in 2000. And of course, the thing that's strange to me, it was after the new provisions went into effect in May of 2000, and I was on the Court of Appeals then. We had a plethora of cases come up as quite a significant change in probation, and it was retroactive, if you remember that whole period.
Yeah.
And Weitzel didn't mention it. And there's two things in that regard. One is, since then, the legislature has amended 6608 or its predecessor 6 times. And it hasn't chosen to correct Weitzel. And you said there's a number of ways that things can be said, and we normally consider acquiescence as being a weak construction provision But when the legislature has been in this statute 6 times and made different amendments, some of which arguably addressed our opinions, but didn't change Whitesell. What does that tell us?
It tells us under the typical rubric of statutory interpretation that if the legislature had intended to change something, they would have changed it. The presumption would be that the provisions that remain unchanged are to be given the effect that they were given prior to the time of the amendment. Where these have remained unchanged, where the court has specifically gone in and put in like the particularized findings for the lower level felonies, but left these untouched with respect to any degree of findings or departure, then the intent of the legislature would be that that was not required. Again, the legislature has told us in a multitude of provisions when substantial and compelling reasons are required. They haven't done that here. And under the plain language of the statute, we cannot read something that's not there.
Why don't you read that from the guidelines? When the guidelines define a departure as a term of non-imprisonment that's beyond the presumptive, why isn't that telling us? Even if it's not in 6608, it's in the guidelines.
Well, first of all, it would still be my primary position that it would have to be here if it's going to need to be done. But also, in the state's position, it's not a departure because the 24 to 60 is the presumptive term. So as long as the court is moving within that 24 to 60, that wouldn't constitute a departure of any kind.
And that's your definition. You would agree there's no place that defines the presumptive non-imprisonment. We have presumptive sentence that's in the grid box, but we don't have anything anywhere that defines presumptive non-imprisonment.
Unless if you were to look at the grid and it shows the sections where there are probation, if you were to say grid box and refer to those terms of probation.
And
Counsel, let's make this the last question if we can.
Okay. The second issue with regard to the May 2000 changes, that cut significantly the period of probation for, I think, 8, 9, and 10.
Yes.
And made them retroactive. And my recollection is that the buzz was those changes were being made to reduce the period of probation, in turn to reduce the opportunity for revocations and to ease prison overcrowding.
I will defer to you on that.
And it seems counterintuitive that the legislature would reduce probation for some of the severity levels and intend for unfettered discretion on the 24 and 36 months to accomplish their goal, to me.
Okay, so I think the best answer I would have to that is that those are lower level felonies. So we're wanting to reduce the prison overcrowding for lower level felonies. But also the amendments at that time still allowed for those to be increased. It wasn't unfettered access, and I don't think it's unfettered access for the upper level, but there is still the potential to increase those crimes as well, or those terms as well, based on particularized findings. So it's not as though they're only left at that bottom level of 12 and 18. There is still the opportunity to increase those as well.
Counsel, we've taken a lot of your time with our questions. Would you like about 60 seconds to wrap up?
Sure. I think our position would be that the legislature knows what language to employ when a particular outcome is desired. They have told us when substantial and compelling reasons are required, and that language has not been included here. If departure findings are necessary, they don't require us to speculate. It would be our position that the Court of Appeals affirming the district court should be affirmed.
Thank you,
Thank
Counsel.
you.
Just a few things to sort of wrap up. As has been already mentioned in terms of direct statutory support, the definition of durational departure in the KSGA refers to a sentence that is inconsistent with the presumptive term of imprisonment or non-imprisonment. And I believe that is consistent with the opinion in Whitesell that refers to the recommended term of probation as the presumptive term of probation, and that those were considered interchangeably in terms of whether or not departures needed and how they apply, that there are presumptive or recommended terms according to the KSGA and the sentencing statutes, but judges are able to have departure sentences from those. And in terms of stare decisis, this of course has been the rule for the last 18 years. The legislature has had ample opportunity to amend the statute if that was not the correct interpretation. It has not done so, and the other amendments to 6608 are consistent with Whitesell, and particularly lay out whether or not for lower severity levels what findings need to be made and whether those are departures.
Counsel, would you agree that if a defendant is paying restitution under a workable plan, that probation can be extended indefinitely under C7?
That is this court's holding in State v. Gordon.
And is that a departure under your theory of departures? Or is that something different?
No, that is an extension of probation via C7. I'm happy to answer any further questions, but I would simply ask that this court reverse the Court of Appeals and remand Mr. Hambricht's case for resentencing.
Do you have any more questions? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.